party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do wish to reserve time, let me know, and I'll keep track of the clock for you, although you will be able to do that yourself. The arguments are being visually and audibly recorded, so please keep your voice up and remain behind the podium. We've read your briefs and we're ready to begin when you are.
I would ask for 3 minutes of rebuttal time, Your Honor.
All right, thank you.
May it please the court, Donald Gallick on behalf of defendant appellant. My first argument in this court, so hopefully it goes well. We come before the court with 3 assignments of error. DUI issue, well, it's a driving under the influence issue, although alcohol is not a factor. Obviously we have the suppression issue. What's interesting about this is the vehicle isn't stopped for any erratic driving. The vehicle stopped for an equipment violation. The court probably saw in the brief, the passenger said, I'm intoxicated, I've had way too much to drink. I don't think the driver, my cousin, has had anything to drink. However, the officer smells marijuana. Now, this raises a lot of issues. We're going to have, I'm sure, a lot more marijuana influence driving arrested here in the future with the change in the law. But the issue is, should the suppression motion have been granted? Now, the officers say during the suppression hearing, they didn't arrest him for driving under the influence. They didn't arrest him for being intoxicated. They arrested him for obstruction. I mean, they're very clear. The reason we arrested Jonathan Keagle is because of obstruction. Well, what was his obstruction? Well, he wouldn't get out of the vehicle. And this raises an interesting question because I cite some case law, I think out of the 4th District, another district, where a non-act isn't supposed to be obstruction. Now, does that delay the officer's performance? Well, certainly it does. I mean, Mr. Keagle's there saying, I don't know if I'm supposed to get out of the car, I don't know if you're supposed to, I'm debating it, I'm thinking about it. That's not what an officer wants to hear. The officer wants to hear, yes, sir, let's get it done immediately. You're delaying this traffic stop. But the interesting paradox in this is that the officer at that point didn't have time to make an arrest, wasn't planning to arrest him for driving under the influence of any substance, but basically arrested him for not doing anything that was illegal, essentially. And certainly an officer, I think there's U.S. Supreme Court precedent, there's plenty of state law precedent, an officer can ask you to step out of the vehicle for the officer's safety or whatever during an investigative stop. But the interesting question, I cite the one case, State versus Certain, it's a certain opinion, out of the 4th District. I think there's another opinion, State versus King, that basically says that something like that should not be obstruction. This court might say, hey, the officer certainly had grounds to investigate him for driving under the influence. He smelled marijuana. His passenger had a lot to drink. But the officer himself during the suppression hearing said that was not my intention. I was not arresting him for driving under the influence. I was arresting him for obstruction of justice. So that's an interesting legal issue.
Counsel, I guess my question would be if it wasn't obstruction, would it have still been some illegal offense?
Your Honor, that's an interesting question. I mean, what is the crime if an officer pulls you over? I mean, there's an equipment violation. I think there's a burned out light or tail light or something like that. The officer has the right to stop that vehicle. The officer has the right to give the operator of that vehicle a traffic ticket. But if the driver says, listen, this is a minor misdemeanor, you're not allowed to arrest me under Ohio law. Everyone knows the law, right? Every driver knows the law. Everyone likes to debate in their own legal theories. Say, hey, look, I know in Ohio you can't arrest me for a minor misdemeanor. I got a burned out light. Give me the ticket and thank you, I'll be on my way. Officer says, I want you to step out of the car. No, I don't think so. I'm not stepping out of the car. We're just giving my ticket and I'll be on my way. Is that illegal?
Except that you have the added component here of the smell of marijuana.
Well, that's true. The smell of marijuana, there's no marijuana in plain sight. I mean, the passenger is intoxicated, but you're not going to arrest the passenger for being an intoxicated passenger. The question is, based on that smell of marijuana, how far does that investigative stop go? I mean, the driver isn't driving erratically. I think the officer even said, and there's video of this, that the car was operating normally, but for the equipment violation. So I don't know. I mean, I certainly, you could say that there's no question that Mr. Keagle delayed the officer's performance, but he did so through a non-act. And so the question is, what can that non-feasance be? I mean, it can't be resisting arrest because he wasn't under arrest. It's an interesting question. And I think looking at that 4th District case of State versus Certain, or the other case, State versus King, this might not be settled law as to what an officer can actually arrest you for not cooperating with a non-arrest. So it's a little bit of a conundrum. Now there's also, and actually assignment of error 2 sort of goes into that, because Mr. Keagle was convicted of the obstruction of apparently not exiting his vehicle. So if you agree with assignment of error 1, you would agree with assignment of error 2, and vice versa. If you think assignment of error 1 is overruled, then probably assignment of error 2 would be overruled as well. They're interrelated. But also, actually all 3 assignments of error interrelate, because the 3rd assignment of error, he's convicted of driving under the influence. There was no erratic driving, there were no field sobriety tests, and there were no chemical tests. What was the driving under the influence? Simply because the officer smelled marijuana, and basically John Keagle basically debated and argued with him the whole time.
Was there any testimony in the record about when the officer first approached the vehicle, about slurred speech, glassy eyes, anything of that nature that would give him a belief that the driver was under the influence?
I don't think there was anything about the manner of speech. I think the officer didn't like the debate. But I can't remember if there was anything about glassy eyes or something that might be associated with contemporaneous marijuana use. I mean, certainly, I don't know if we have settled law on, but I don't think, well, we're not here on any kind of statute for prohibitive marijuana usage or anything like that. But the driver was driving, he wasn't cited for any improper driving. The officer didn't witness any improper driving. And basically, his complaint about Mr. Keagle was basically his legal debate with him. I'm going to debate whether I should get out of the car. I'm going to debate if you should stop me. I want to debate all these other issues. And certainly, there's no question that delayed the officer's performance. But is that evidence of intoxication? I mean, the officer pretty much says, I smelled marijuana. His passenger was admittedly intoxicated, and Mr. Keagle is giving me a very rough time here. I'm just asking to get out of his car. I'm going to arrest him for obstruction of official business. And later, we're going to add on the driving under the influence. When they get it back to the station, they don't say, well, now that we're here, let's do some field sobriety tests. Let's do this. They're not even interested in that. They're not even thinking about operating a vehicle under the influence. And during the suppression issue, I think the officer is very clear. This wasn't a driving under the influence arrest. I'm arresting him for obstruction. I mean, apparently, if Mr. Keagle, from reading the suppression transcript, Mr. Keagle would have just gotten out of the car and the officer spent a couple more minutes, he would have put Keagle back in the car and sent him on his way with his broken taillight ticket or whatever.
Or he would have searched the car.
Well, he could have done a wingspan search and see if, and found, I think there was some hemp seeds or some other kind of marijuana paraphernalia in this. It's a little confusing. I mean, we're here on a consolidated appeal. Every charge was a separate citation. So I think the court has like 8 journal entries in front of it, or 8 citation forms in front of it, which is a little unusual. But there was, after the arrest, there was marijuana or some drug paraphernalia found. I can't remember if it was hemp seeds or something or other like that. And those were all minor misdemeanors as well. The only non-minor misdemeanor, I think at least 8 convictions here, but the only degree misdemeanors are obstruction of official business and operating a vehicle under the influence. And many of the minor misdemeanors were not even challenging. Obviously, there was broken tail light, and they found this drug paraphernalia, drug seeds, or whatever it was. If the suppression is granted, then those would go away as regards to that. But
Well, drug paraphernalia is not a minor misdemeanor.
I can't remember if we're here on a second degree misdemeanor drug paraphernalia. I'll have to go back and check on that. Because what I remember, is that they were a long stack of citations that were all issued separately. But I think there's multiple counts here of either marijuana possession, minor misdemeanor, or marijuana hemp seeds or something to that effect.
Counsel, you talked about evidence of intoxication. It's not really the standard here, though, is it?
You know,
Looking at evidence of impairment, those aren't necessarily the same thing.
that you would be right. The word usage is kind of clumsy. I mean, I just.
So what's the evidence of impairment, or I suppose I should be asking your opponent that question?
Well, I mean, the officer didn't state that he had any familiarity with Mr. Keagle. Didn't say, oh, I've arrested this guy before, I've seen this guy a long time. It could be that there are some people, we've all met them, that they debate every legal issue you bring up. I mean, the officer stops and gives you a speeding ticket. Well, you can't do that unless the laser is calibrated. I mean, this court sees pro se defendants. They know the law better than you do. They know all about the law. Mr. Keagle is debating whether or not the officer can order him out of the car. And that's very disruptive to the police officer. I understand it. That's delaying the police officer. But is that evidence of his being under the influence or intoxicated or drugged out of his mind? Or is that just normal behavior? The officer doesn't know. The officer doesn't know, well, he only gets this way when he's using marijuana. He's never seen him before. So I don't know what the evidence is of him being under the influence other than being argumentative. And again, the operating a vehicle under the influence was thrown in as an afterthought. They were taking him down to the station for obstruction. They didn't seem to have any interest in investigating for operating a vehicle under the influence. If there's no other questions, I would reserve the balance of my time.
Morning, Your Honors. My name is Mark Cadetti. I have the pleasure of appearing before you today on behalf of the City of Macedonia, Ohio. Appreciate your time this morning. From the outset, I have to say that I like to say that I've been around the block once, not twice, but once. In my short tenure as an attorney, I've noticed it's all too easy to lose sight of the specific facts of the case, particularly when they're pertinent, if not essential, which is the case here. So I'd like to briefly go over some of these facts, as Your Honors had a couple questions for Appellant's counsel. During October 28th, 2017, the stop and arrest of the defendant was operating the vehicle with no taillights. Both windows of the vehicle were down, despite it being 40 degrees outside. The defendant could not immediately respond to simple questions when he was asked. For example, when the officer asked, "What's your name, sir?" He said, and couldn't give a straight answer. There was an odor of marijuana emanating from the vehicle immediately upon the officer's approach. The defendant had bloodshot, watery eyes, and his speech was abnormally slow. And the officer noticed these and observed these facts immediately on approaching the vehicle. Now, I agree with counsel for the appellant that assignments of error 1 and 2 are both linked. The essential question, whether you're taking a look at the motion to suppress or whether there's sufficient evidence presented to the jury to sustain the conviction for the obstruction charge, it comes down to whether in fact there was an affirmative act. And the case law in Ohio was pretty clear on this actually, despite what the appellant argues. And the case law states that the argumentative nature of the appellant's conduct is sufficient and constitutes an affirmative act to satisfy the statute. There's several cases cited in the appellee's brief, including State v. Hunt and State v. Karachi, both of which explicitly held that the defendant remaining in the driver's seat of a vehicle after being ordered to exit the vehicle constitutes an affirmative act. It's worth noting that the position the defendant's in at that time, being in the driver's seat of the vehicle, he's in a position of power. It's a dangerous position. He could start the vehicle, take off. That's why this isn't your traditional case where there's a dismissal because there's no affirmative act. Those are more introductory Terry stop scenarios where the officer says, "Okay, tell me your name," and the guy refuses to give the name. That's not what we have here. We have a guy stopped, lengthy interaction with the officer. He's refusing to cooperate at all. keep in mind, 10 minutes elapsed, 10 minutes of argument. This isn't 1 or 2 questions. This is 10 minutes of arguing with the officers, giving, basically trying to interrogate the officers himself, giving all kinds of responses other than cooperating with the officers. A number of officers had to respond to the scene, and it's also important to note that it was not until the officers actually applied force by contacting the defendant did the defendant get out of the vehicle after approximately 10 minutes. So it's clear that there's an affirmative act that occurred. Now, in regard to the third assignment of error, I completely disagree with the appellant's characterization that the police had no interest in pursuing an OVI investigation. That, of course, was part of the process for the entire duration of the stop, especially with the observation of bloodshot glassy eyes, the slurred speech, inability to understand basic questions. So the fact that he was placed under arrest for obstruction, taken to the station to conduct standardized field sobriety testing, is not unusual at all, particularly where you have a defendant who's so argumentative, his behavior is so unusual. The officers can always take back to the station in a protective environment to conduct those testing. Now here, the defendant refused to take the test, but that doesn't mean that they couldn't have transported him to continue the OVI investigation. Now, they could have arrested him, in my personal opinion, at the time of the arrest for the obstruction, but they chose to continue the investigation, and that was perfectly proper.
So they didn't arrest him at the scene for obstruction?
He was arrested at the scene for obstruction,
Okay.
then later he had the OVI charge after he got back to the station. So obstruction initially, and then the OVI.
Okay.
So, based on all the foregoing facts, we'd ask that the trial court and jury's convictions be affirmed. Thank you, Your Honor.
This is a situation where sometimes the facts in law are just opposed. I can certainly understand an officer saying, I don't want to be able to pull someone over and ask him to step out of the car, and he says, I'm not going to. But as far as a violation of 292131, there's several court precedents from other districts. Perhaps this court won't agree with them, which is fine. But says that the failure to obey law enforcement officer is not obstruction of official business. Mr. Keagle isn't threatening the officer. He isn't, doing anything to make the officer think he's going to be violent to him or hostile to him or anything like that. But I'm not getting out of the car, not interested in it. I'm going to ignore you. I'm going to be silent. Mr. Keagle could have not given his name, not said one word. It's not obstruction of official business according to State versus Certain or State versus King. There's another 2005 case I cited, State versus Prestel, that says it's not a violation of obstruction of official business. I did cite just sort of for academic reasons, it might be a violation of 4513.36. That's not charged in this case, has nothing to do with this case, but I could certainly see this court saying if it's not obstruction of official business, it should be something else. But it isn't a violation of obstruction of official business under the 3 cases that I cited. And again, this court might not find any of those cases persuasive, but they are the law in other parts of Ohio. If there's no other questions, I thank the court for its time. Thank you.
Thank you both for your presentations. The court will take the matter under advisement and issue a written decision, which will be